welcome. This is
Well, hello, Bill. How you doing?
good. How are you, Nick?
Good. What's the good news for today?
Okay, well, first we'll just start with the usual opening. Welcome. This is to IBM International Broadcast Media. This is the Lawyer's Den. I, Bill Trezevant, will serve as your co-host along with my esteemed Southern gentleman, Nicholas Palavita. Each evening or each episode, we explore the important issues of the day, confronting various legal matters with the top legal scholars that, well, frankly, that will agree to show up. So, with that in mind, Nick, I hand it over to you, please.
Well, I'm glad you did, because the thing is, we need to get some competent people on board here, which is part of the goal of the Lawyer's Den. So, everybody, welcome to the Lawyer's Den, broadcasting out of Raleigh-Durham, North Carolina, and the Tower of Power of Washington, D.C., which where Bill Trezevant happens to hang out. He even shakes the president's hands, for what that's worth. But we have some very important panelists today, and of course, hailing from Salt Lake City with a JD LLM, we have our esteemed guest licensed before the United States Supreme Court. We would like to bring in our panelist, Jeff Teichert, who, by the way, has his own cult following in the Salt Lake City area, which is pretty strong. But he's also a constitutional scholar. And as you know, the thing is, we're starting to get some people from India on the show, which I'll talk to these guys later about that. We may have to boost this back an hour because it's 4:30 in the morning for our New Delhi friends. But where you can actually get a good deli in Georgia, Midgeville, Georgia, they actually do have good delis there. We have a constitutional law professor, Adam Lamparello. Adam, welcome to the show.
Great to be here.
It's good to have a real professor, and I'm so jealous of you, because the thing is, it was one of my dreams. Now it became a daydream as you get older, to become a professor somewhere at some university. But as I am totally unhireable in any capacity at any company or institution in the world, that remains still to be a daydream. And frankly, Adam, I've been unemployed for 37 years. So when you're unemployed like me for 37 years and I apply for a job, they go, "Who's this strange guy that's showing up?" Well, did you ever work for anybody? No. Well, how'd you do that? Okay, a true story. I graduated from law school. I started my own law practice. All right. In other words, went right to private practice. Bang. And I was making, as a clerk back then, I guess, does that count for being practicing law? The whopping $8.50 an hour. And I was actually, this is a true story, I was actually teaching as an instructor at University of Denver Law School at the whopping price of $5.50 an hour. Okay, wow. So I know that was wow. What? Well, of course, this convinced me that academia was not in my cards. Okay, at $5.50 an hour at University of Denver Law School. Okay, so what I did is I started private practice. First week I made $3,650. By basically doing trust work down in Florida for the 1% that Bill's totally envious of in Fort Myers and Naples. In other words, I started hanging around rich people, baby.
Academia needs more people with real world experience like you.
But no, they don't want me. I mean, the thing is, I am a big pain in their rear. So the thing is,
no. If I might, because Nick, I really want to help you on this. Because
do you know how many times I've been rejected from every academic job in America? But maybe it's because I graduated magna cum barely where I went. So the thing is, it was a whole different story. But I have my excuse. Okay. I got an excuse.
No. That's like, look, I want to help burnish your CV here, and for the uninitiated, that's the only word they allow us JDs to use, which really means curriculum vitae, meaning what's your legal rap sheet. Now,
right.
Nick actually did have a job, but the students, and Adam, I don't know how you pull this off, but the students actually rate the professors, and Nick was downgraded because he gave too much work.
It's true. I got called to the dean's office 3 times. I've never had that before. Okay, and I wanted the dean. What's the complaint? You work these people too hard. I said, what? Me? You don't understand me. I mean, they really didn't get. I really wasn't working too hard, but I do enjoy what I'm doing. So I asked them to participate. Okay, but part of my academic career was at the University of Miami Law School. Let me tell you the problem. There was no problem with the law students, okay, because they're all working hard. All right, which was not in my cards because the golf game was hurting. But they had these undergraduates, these young lady undergraduate party people, and it kind of like went arc. So the thing is, after my first year, And I had a lot of places where I was number 2 in my class. I was going, this is way too much hard work. I was watching, they're working like 110 hours a week. And I looked over here, oh, these are the undergraduates. Well, there goes my GPA. Okay, so I don't know if that counts for anything, but apparently it doesn't look too good on your resume. So Amy Coney Barrett, whatever her name is, graduated number 1 in her class. I said, well, that's way too much work. So anyway, yeah, my academic career is limited to teaching at the great Northeastern University graduate tax program. The only reason they accepted me there, because in graduate tax, is I was in Seattle and they were looking for somebody who knew about retirement plans and qualified plans. And the real problem is most attorneys don't get into actuarial science because it's math oriented. And so the thing is, I had kind of what they call a USP, unique selling proposition, something I did. And I said, hey, look, I'm actuarial pension attorney. And they go, oh, we can't find any of these people. So they hired me at the GTP program 10 years ago. And
you should be extremely valuable then, because you're giving students real world skills, which is exactly what they need, rather than theory and nonsense that won't serve them in the real world.
What?
I couldn't have said it better myself, Adam.
Oh, well, maybe. I mean, the thing is, it's a whole different way of life, let's put it that way. But I'm so envious of you that all you have to do is show up, get paid, sit and talk to people, talk to a bunch of students, okay, who don't know anything. Let's face it, a 1L or even a undergraduate, they don't know anything. They believe you walk on water because they've never seen a golf before, And the thing is, and then you get to go home at night and say, forget about it. And so the thing is, this is the ultimate cush job that I so endlessly wanted, but have no possibility of ever getting. And my future deck is stacked totally against me. So it's
you would be shocked at how much work it is and how hard and how many long hours.
Okay, you're talking me out of it. Okay, see, that's not in the cards, baby. This hard work stuff. No. So, anyway, we'll have a conversation on academia at some other point in time, but it doesn't matter. I'm unemployable. And we interviewed this guy who founded Yapstone. He's on one of our shows. Okay. Now, his name's Tom Vellante. He became a good friend. Even his daughter came down here about a year ago when we were filming. And Tom runs a $17 billion company. Maybe 21 billion now. So I asked Tom, I said, Tom, how'd you happen to get into it? He goes, dude, you don't know me. It's out of California, of course. The dude is normal. He goes, I'm totally unemployable. I said, yes. Okay. I totally understand that. And so he's the CEO and founder of Yapstone. So we run across all these CEOs. A lot of them, the reason they're there is they're unemployable. Okay. And so they end up becoming CEOs of companies. And that's how America is made. The greatness of America is made on the backs of unemployed people. With that,
what an introduction, Nicholas! Dropping the mic before you were even given it.
Yeah. Go Northeastern. Well, let me put it this way, Bill. Okay, lawyers in general are kind of pseudo boring. I mean, let's get real. Yeah. All right. I mean, the thing is, I was going through this case, a new case that came out. Epic Games versus Google. Remember went over it yesterday? Well, that was just the DOL versus Google. There's a sister case that came in before it for antitrust, Epic Games versus Google. And it's something I really wanted to discuss. But also there was another thing, the 1MBD scandal that just got settled. I don't know if anybody's familiar with this. Back here, I have a wonderful book recommended by my friend, Bill Gates. Now, I have to build my Bill Gates stories, by the way, because remember, I used to live in Seattle, and my wife is from Seattle, living in a place called Laurelhurst, where Bill Gates grew up. So her family knew, they knew the Gates family real well, because, as a matter of fact, Mrs. Gates went to their home crying, Bill's dropping out of Harvard, it's horrible. And my wife went to the same school they went to, which was St. Nick's, and also was the Lakeside School. Okay. And so the thing is, the Gateses were actually, pretty well-known people. So Bill recommended this book, and I recommend it, $1 Billion Whale. All right. And this was written by people from the Wall Street Journal. I apologize for all the liberals. It was written by people from the Wall Street Journal, but it's a great story about J. Lo, who embezzled like $5 billion from Malaysia. Okay, and it's cute. It gives you a whole blueprint on how to embezzle money. And I started my career early off chasing people like that. Matter of fact, our first lawsuit was against Elliott Securities in Naples, Florida, who Ponzi'd about 60 million. Not near what this guy does, 5 billion. Okay, but it's such a blueprint, such a great story. And if you read through it, one of the see, they do legitimate and illegitimate things. Illegitimate is just siphon the money into their Swiss bank accounts. The legitimate is they actually invested in a movie called movie production company called Red Granite that did 2 movies. One, Dumb and Dumber. Okay.
Oh, wow.
All right. Now, if you read the Department of Justice complaint about they're getting all the royalties back from Dumb and Dumber, but the other movie they invested in that was very successful, The Wolf of Wall Street, with Leonardo DiCaprio. So it is a great read, a great story, a true story. And for all those people that decide, oh, I'm not going to be a lawyer, but I want to make a lot of money, and I don't really care that much about the law. Well, here's your blueprint for $1 billion. Oh, he's in China right now, the guy who embezzled, because the Chinese government is kind of keeping protection over him while he still keeps his billions offshore. It's a great story. Eventually, I think it will be a book. And it is, you can actually follow it. I was about to print it off. It's like a 280-page complaint from the Department of Justice versus all these people trying to recapture all these assets. Wow. And I think they get a revenue share out of it or something like that. And that's the reason they do it. So to me, that's exciting. That makes interest. Now, I know you guys don't want to talk about this. You want to talk about Roe versus Wade.
I knew you were going to say that.
Roe versus Wade. Okay. I mean, the thing is,
Nick,
Roe versus Wade.
Nick, I'm going to start by this. In defense of the legal profession, you know which attorneys have the best stories? And it's not that I'm biased or anything, but it's labor attorneys, because you wouldn't believe what people try to get away with in the workplace, both on management and on labor side. It's just, and everybody thinks it's written in the Constitution. And had I known Adam way back when, I would have said, please, I'd like you to meet my friend Adam. He will tell you what is in the Constitution and what clearly is not covered under the originalist words. And you getting fired for stupidity is not covered by the United States Constitution. But that having been said, labor attorneys have the funniest stories ever. Just go talk to one. And then maybe tax attorneys. But entirely up to you. Do you guys have any favorites of the legal profession who tell the best stories? Because you're right, Nick. It can be really, really boring at a cocktail party.
It is boring, but they may have some more exciting stories. Mine is just really working with people that embezzled monies and funds, which I can spend more time with. But they have some more interesting stories like Roe versus Wade.
Griswold.
Griswold versus Connecticut.
New York. Well, fine. Jeff, okay. We haven't given you a chance to say hello yet, and that's predominantly because we've got old man Windbags who used to make $8 an hour, and he called that a job. Please, seriously. Jeff, how are you this evening?
I'm good. Thank you.
Okay. You have any interesting stories that you want to share with us? Like the time that, I'm listening. Go ahead.
Oh, I mean, I'm sure I've got practitioner war stories if I think about it. I'm kind of like Nick. I've had a job for 1 year out of the last 21. So it's I've kind of had to make my way on my own and do some crazy things. When I first started a firm, I did phone surveys at night while I practiced law during the day, because you had to do something to make a living while you're getting the practice up and going.
Well, it's and actors and actresses think they have it tough when they wait tables. At least they get to go home with some food. Now, I do have something on the agenda that just seems to me, and I'm going to buy person. Just go ahead and utilize whatever little authority I do or do not have here in the media world, and that is simply I'm going to grant cert to this notion, and it is a well, once more into the breach. Joe Biden today finally answered the question on whether or not he would pack the Supreme Court. Now, on the one hand, for all of us, that may mean a new job opportunity, because with each justice, forget those jobs, there are all those law clerks, plus all the other people in the technical. I mean, it could be a full employment plan, but the litigation alone, the briefings, the lobbyists, you name it, all the way up and through. But more importantly, according to Democratic candidate Biden, he would, if he were elected, put together a presidential commission made up of scholars, liberals, conservatives, Republicans, Democrats, and have them comprehensively study. Now, get this, because it's a little broader than what we talked about last time. He would study reforms to the entire court system, not just the Supreme Court. So he made it a little broader than the court packing plan. And there are a number of things that, might flow from this tree. So, Adam, you get a second bite at the apple, but this time your white paper has to include the entire judicial system. And Jeff, it makes it broader so that you can come in with your ideas from out west, maybe some libertarian ideas that might keep, the government from peering into, Nick's wallet through the Patriot Act or something. I mean, it seems to me that we have a broad branch. Now, what I would like to do is I'd like to see who would like to start. Is it Adam from the South or Jeff from the West?
Well, I'd be happy to. Okay, I'll be happy to start. I think, honestly, if Joe Biden just listened to the following 3 suggestions that I have, then he wouldn't need any commissioner, and we'd be all fine. Be happy originalists. Number 1, at the Supreme Court, implement a supermajority requirement where you require 6 votes to have a majority opinion. Number 2, I would amend the Constitution and I would permit advisory opinions, particularly to facial challenges to statutes. And I would also expand the U.S. Supreme Court's original jurisdiction, particularly to address facial challenges. Because why do we have to wait 5, 6, 7 years for a case to get to the Supreme Court to have a single legal issue resolved? It's inefficient. And if Biden wants to be more practical and he wants to be more fair, let's bring in advisory opinions. Let's amend the Constitution to expand the court's original jurisdiction, and let's have a 6-3 supermajority requirement.
Jeff?
Well, there are a number of reforms that I would like to see occur. The biggest one being, I would like to see a national court of appeals between the circuit courts of appeal and the Supreme Court. I've argued for that, and I know other people have for 20 odd years, and it doesn't happen because the circuit justices like to be right below the Supremes, and so they fight it every time it comes up. But I think it would be a good idea. I think they could resolve a lot more splits in the circuits and create more uniformity through the federal system, which I think would be a good thing, to have the laws interpreted the same way around the country. I am not happy with the idea that hidden inside this agenda might be attempts to pack the court or increase the number of justices. I think we've had 9 justices for over 100 years. I think it's worked well on the whole. I don't want to see that change for political reasons, even if we're putting in place bipartisan commissions to sort of cloak it in an air of legitimacy. I guess the other thing, and this may or may not be applicable, but I'll throw it out there. I am not necessarily a huge fan of governing by experts. The idea that we bring a bunch of wise old men into a room and they're going to come up with a better answer than the general public does, than our elected representatives do. I think we've already got way too much of that kind of thing, independent regulatory agencies and boards and things like that in our government. I don't think we need another one to study something and tell us what we ought to do. When I was running for the Court of Appeals, Nick may remember this, in Washington, I was asked on a questionnaire by one of the groups that endorses judicial candidates, would I favor a system where the state bar would recommend a list of names from which judges could be chosen by the governor or whatever, and I don't favor that. I believe that there is inherently a political component in appointing judges. I think having the attorneys appoint the judges they practice in front of is kind of like having lobbyists appoint the congressman. I mean, I just don't think it's a good idea. So I don't know if that's the kind of thing that that this bipartisan commission would do, but I'm not, I am for certain reforms. I'm not sure it takes some sort of special commission or board to come up with the ideas.
Nick.
Well, I'm starting to hear innovation here on IBM TV. It's kind of amazing that these two people are actually innovation, which Innovation Nation is not part of the legal system. You do understand that, Bill, that we're trying to regress, not progress, into the 17th century. Okay, well, we have to say something to compete against Judge Judy. She's getting all the love tonight. She's on at 7 o'clock, Bill. Think about it. And there they get to listen about people, oh, I didn't pay my rent. I need to see my sister. And the thing is, that stuff is interesting. This stuff, at least from I've seen a lot of courtroom work, is jurisdictional. In other words, they move a lot of the courtroom work is jurisdictional. In other words, jurisdictional issues. And then what was it that I was doing today? Oh, I was doing a presentation on the EBSA, the Employee Benefit Security Administration. And if you read through the language of the EBSA, it's all subjective. You can charge reasonable fees. You have to do things that is permanent. They put all these subjective things into the law, and all my advisors are going, well, how do we abide by all these subjective things that are out there? You have to choose mutual funds that are the quote best interest of the participant. The law is riddled with all these subjective and not quantifiable positions, creating a place where a cesspool of arguments can take place. Now, one thing that we could reform is to quantify more, use artificial intelligence more. I know that's above the scope of this conversation, to be able to render decisions that are more and they're clear. And right now, there's a whole movement in the legal tech area where, gosh, I should bring the attorneys on. There's one in Campbell and there's one at Chicago Kent, that they're actually using this to make better decisions rather than, well, I don't know, that looks like a reasonable fee to me. What do you think, George? And that's what we have out there. So for what it's worth, it's very subjective.
Okay, wow. Artificial intelligence. It's the ever creeping notion that Big Blue should be governing our lives, Nick.
Yeah, well, the thing is quantifiable data. If you look at a lot of these decisions, a lot of things out there, they're couched in very amorphous language that can be interpreted a lot of different ways, and it's not quantifiable. The more you quantify things, the better off you're going to have consistent decisions. And as you work around the world, what they're looking for in our legal system is a structure that's quantifiable and reasonable. I shouldn't use that word, should I? Because that depends on who believes the reasonable man is. But I've been involved in cases, Bill, that I get hooked in these jurisdictional nightmares that really just shouldn't exist, and it creates an outcome that shouldn't be there. And so his call for judicial reform, I think, is correct, and I do believe what they do have to do is bring scholars and people that actually work in the area to the table. But that's not what's going to happen, Bill. They're going to bring a bunch of bureaucrats.
No, not quite so fast, Nick. Because I'm going to make sure that hope springs eternal from your heart, because we are going to root for one of our own here, and that is Professor Adam Lamparelli. Because I would like to explore your idea of original jurisdiction as a way of streamlining the court. Because, quite frankly, Nick, my personal bet would be, my hope is that he would be one of the scholars on that commission. I think that he would really give everybody else a run for their money. But just to make it fair for them, Adam, I want because I can't just have you blowing in with all these radical ideas that they're completely unprepared. So first, we've heard about your idea of a supermajority. That's neither here nor there. But this original jurisdiction expansion of authority is a new one for us. Can you explain at first what it currently is for our audience, because it's both worldwide as well as domestic, and also what you mean and how it would help, please?
Sure. The U.S. Supreme Court has both original and appellate jurisdiction over cases and controversies. Its original jurisdiction, its ability to hear a case before any other court hears it, the trial courts or the appellate courts, is very limited. My proposal would be to expand the court's original jurisdiction so that it would lead to much more efficiency, predictability, and stability in the law. And I'll give you an example. In Obergefell versus Hodges, the court held that the 14th Amendment protects the right to same-sex marriage, but it did so only after several years in which the circuit courts of appeal, like the Seventh Circuit in Baskin versus Bogan and the Sixth Circuit, in an opinion by my former professor, Jeff Hutton, went through these issues. Well, what I would do is I would have the Supreme Court hear it initially. Why do we have to wait several years to get a resolution on the issue when it doesn't involve any specific facts? It involves a question of law. So we wait until the first, sixth, seventh, eighth circuits split. They come to different opinions. But all this time, people are being deprived of what ultimately is deemed a fundamental right. Let's start at the Supreme Court and end it quickly when we have facial challenges to statutes.
Okay, let me. And that is, we do need a record. Okay, and so, and I guess under that theory, the Supreme Court would actually be the trier of fact and then exercise its jurisdiction under your theory. Am I correct with that, Adam, or no?
Not necessarily. I think on a case like, do same-sex marriage bans violate the Constitution, or does a woman have a right to terminate a pregnancy? There's not really much of a record you need to develop. It's really a legal question. It's a legal question in the due process and equal protection clause.
Okay, I mean, I understand that, Adam. Except that look, I was with you all the way up to when you said we really don't need a transcript, because then that just becomes, isn't that just like an American suggestion box? Like, hey, Judge Roberts, I think you ought to take a look at this piece of the Constitution, and I drop a little note in a box outside the Supreme Court. We really kind of need a record to say, just to beat that there's an actual case in controversy, don't we, Adam?
I don't agree, respectfully. I think it's a purely legal question. For example, in Washington versus Glucksberg, the court confronted the issue of whether a person has a right to die if they have a terminal illness. There really isn't that many facts that you need to know. It's a purely legal question. Does the Constitution permit this? Does the Constitution permit same-sex marriage? You don't really need a record, and I don't think any experts are going to add anything in the way of analysis.
Okay. Well, I mean, this is just radicalness to my ears. A lawyer, a professor, is telling me that I don't even need to put on witnesses to get a judicial order. What are your feelings on that, Jeff?
Well, it would it would require a constitutional amendment, like Adam has proposed, to remove the cases in controversy requirement from the Constitution. And in fact, there are factual issues involved in those cases. I understand they don't predominate, but for example, you may have an issue about whether or not somebody is actually terminally ill. And so that's, that would have to be proven unless you could somehow certify the question to the Supreme Court and get a, stipulation and a quick resolution to it. So I think it would overturn 2 centuries of precedent. I'm not sure that I like the idea, but I do see what he's saying. I mean, it can take several years for a case to wend its way all the way to the Supreme Court, and by that time, for the litigants involved, it's usually moot.
Well, Nick, wouldn't that just lead to cherry picking? I mean, if the Supreme Court could go in and pick and choose and just say, on this case, we're going to exercise original jurisdiction, but on this case, no, you people, you guys are going to, I'll see you in a decade if I'm still around.
See, it's really a problem with Adam. See, brilliant people don't belong out with brilliant ideas, because have you ever seen the TV show Pawn Stars, right? And the guy looks at you and go, you want a constitutional amendment? He goes, that ain't happening. Okay. And so the thing is, in reality, you can forget that. It just ain't going to happen. So there won't be the other problem with it. Original jurisdiction. Do you know, out of they have 1,000 cases. They get to select one. They don't have time to look at all those cases. So you have to increase the size of the court, or have specialty courts like the U.S. Tax Court, which is a court of national jurisdiction, and have more specialty courts out there so they don't have to listen to all that stuff. And the other problem I have, and this is between me and all this stuff, we spend an enormous amount of time on LBGQ cases, Roe versus Wade cases. In the meantime, this guy is siphoning off, kickbacking $8 to $12 billion, and then siphoning money and sending it offshore. Oh, we're going to ignore that, because it's more important to look at all these social issues while we're being robbed blind and going broke. Ultimately, the America is going now. Not to say there should be time spent on that. There should, but they've got to limit the time there and look at how are we going to progress as a nation economically, or everybody on this panel will be speaking Mandarin in the next 20 years. Okay, and that is the reality, Americans. And we're going to be bringing on our international people shortly. We may have to move our time back about an hour to listen to how the rest of the world views us, because we get a very insular viewpoint of ourselves, including your friend Amy Coney Barrett, who never went outside the United States except maybe to vacation, and has no clue that the rest of the world is big, huge, and frankly, we're watching ourselves shrink like a violet.
All right.
We spend too much time in the wrong.
No. Out of fairness, I'm Adam. I know that you're chomping at a bit. Do you have a response, please? And then I do have another question, but go ahead, Adam, please. Out of
In
fairness.
Riley versus California, the court
He's
held
the law again, Nick. Nick, he's using the law again. I don't know what program we're running here.
I figure Riley versus California. I mean,
in Riley versus California, the court held that searches incident to arrest under the Fourth Amendment could not include searches of a cell phone because cell phones contained information that was so private that it mirrored the papers and effects traditionally protected under the Fourth Amendment. It took years for the court to get to that decision. And in the meantime, arrestees were having their cell phones searched, their private information exposed. If you want real change to the court system, it's going to require something radical. The court should have decided that case right away. Why are we letting the First Circuit Court of Appeals come to one conclusion, holding the information as protected, the California Supreme Court coming to the opposite conclusion, and it's only several years later that we finally get a decision? Let's get a decision right away because it doesn't require much at all, and it protects the people, and it protects rights more substantially.
Okay.
And I love Amy Coney Barrett.
I totally agree with him. I totally agree with him. Because the thing is, the issue is a waste of time to begin with, so you better spend 15 minutes and get it over with. Okay, and then go spend time on real issues that move America forward, not some dude who's having his cell phone investigated. That is a waste of time and money, counselor. I'm sorry. Okay. Next case.
Hey, Judge Calavita has banged his gavel, and I happen to have his gavel, and we will use it. So that part is done. Now, Jeff, I want to go to you, and then I want to come back, and I'm going to ask this question eventually. But Jeff, what do you think of the lickety-split in and out justice that Adam is discussing? Is it worthwhile under that theory?
Like I said, I'm not for it. I also have a certain amount of sympathy for what Nick just said. And if you want me to concoct a wild conspiracy theory, I'm happy to do it. But I do think a lot of our time is wasted on small issues. While, I mean, I was on a trade mission to China in 2018 with a group of other Utah business leaders. Mm-hmm. And I mean, what I saw over there was mind-boggling, just mind-boggling. So I do feel like to some degree we're fiddling while Rome burns with a lot of the issues that we take up.
Okay. Well, I appreciate that, my fellow.
I agree with both the panelists for different reasons. I agree with Adam that it needs to be streamlined because they're wasting a lot of time and resources on an incredibly stupid issue. And I agree with Jeff that the thing is, China and the rest of the world are eating our lunch while we're wasting our time with whether or not a cell phone is going to be searched or not. Get it done and move into do something productive. Hello.
Okay, then fine. Then that causes me to raise this particular question, and that is, where do we draw the line with regard to which issues should be fast-tracked and which issues shouldn't be? So, for example, because remember, it was Biden's comments that said that he was looking at the entire court system, and I've given you guys deference in order to just talk about the Supreme Court. However, there has been a growing chorus of voices that have been talking about systematic changes across the entire United States court system. Most notably, during the summer of civil unrest, we've had the advent of various types of protests, most prominently Black Lives Matter, raising the issue of criminal justice and the disparate treatment of minorities and people of color within the system. And is that something that should be addressed as well? I mean, I know that it's inconvenient for this panel to discuss such murky issues, but some might say that an issue such as criminal justice reform should be one of those fast-tracked matters as well. Would you guys agree?
Well, you guys can go on, then the mouth of the South will speak.
Okay. All right. Okay. Jeff?
Well, yeah, I mean, I think it needs to be addressed. When you were talking about reforming every level of the system, I was thinking about the rules of civil procedure and how so many of them violate due process of law. I'll give you a simple, super boring example. You can file requests for admission, which means you ask the other party to admit that certain statements are true. And if they don't respond within 30 days, those matters are deemed admitted. And you have to go through all kinds of procedural hoops trying to get your admissions withdrawn. The burden of proof changes and everything. Now, that is one of the stupidest things I've ever heard of. You can file a totally frivolous lawsuit and then file requests for admission. And if somebody forgets to answer within a month, boom, you've suddenly got a big judgment. Mm-hmm. That is completely ridiculous. And I could point out one example after another in the rules of civil procedure that are meant to expedite litigation that end up resulting in filing motion after motion of procedural crap. And I would like to see a lot of that end.
Okay.
Now, with regard to the question you asked regarding race, mm-hmm. I think most cops are pretty decent guys. But having said that, there are bad cops out there, and I am, as a libertarian or a libertarian-leaning conservative, I'm inherently suspicious of government. I think we need to take that system apart and put it back together. And frankly, I'd like to see a lot more black police officers. I'd like to see officers that will help change that system from the inside out.
Okay, quickly, before I go to Adam, Jeff, I just want to drill down on that question, because earlier you were talking about, you essentially took a position that said, we don't need, you didn't like government being run by subject matter experts. Now, in order to untangle the issue of criminal justice reform and disparate sentences, wouldn't you need some experts on the matter to serve on the panel to really get to the root of it, or would you just let any old person kind of come in and just shoot from the hip and reform the criminal justice system?
Well, in terms of police, that's largely a state and local issue. I would have it reformed by the legislatures. Rather than trying to do it at the federal level. And I think a one-size-fits-all solution isn't necessarily going to work well. We've got far different problems, say, here in Salt Lake City than they might have in Detroit. So I would like to see that done at the state and local level, and only have the feds step in if you've got a jurisdiction that's really where it's so systemic and that the majority literally won't clean it up.
Okay, Adam, do Black Lives Matter issues get fast-tracked under your adjustments?
No, I think that Black Lives Matter issues should be resolved by the state legislatures, because each state has different and unique problems that should be addressed on an individual basis. One of the issues that could be addressed and maybe should be addressed is qualified immunity. I also, honestly, I take issue with the idea that disparate impact is always or usually a constitutional violation. I think it's a terrible aspect of equal protection jurisprudence and should be revisited. Regarding original jurisdiction, I would limit original jurisdiction by the Supreme Court to facial challenges to statutes based on purely legal questions. I would also bring back advisory opinions. Let's let the legislatures ask the court if it's going to be constitutional before we go into this multi-year litigation that's going to cost so much money, waste so much time, and lead to so much instability. And let's look at what other countries do. Other countries do this. Why can't we?
Nick, I think he just a safe ball right down the middle in the strike zone, being a pitcher. He said, let's look to other countries. What are your thoughts on that, Nick?
Yeah, I mean, absolutely. You want to look and see how other countries deal with their criminal justice system. Remember, in the United States, we have two legal systems. One for the rich, it's called civil law. Second one for the poor, it's called criminal law. So the thing is, the rich who can steal $8 billion, they just go to court. The poor, if they stole $8 billion, they'd be locked up in jail. It's a whole different cat Bill. And the thing is, we have two different legal systems, and white collar crime is actually 100 times more costly than the guy who robs a stupid 7-Eleven. And they don't know that. In other words, the person who Ponzi schemed out from the bank inside the bank is, and they've done studies on 100 times greater. Now let's see part of what the problem is. First of all, since you guys love case law, it's a very famous case, Jordan versus the city of New London. Now, for those who read Jordan versus the city of New London, which is a 2000, it was actually in the year 2000, I believe, Second Circuit Court of Appeals case. It said this, quote, if your IQ is over 125, you're too smart to be a police officer and you get bounced from the force. And it was considered legal. It's a permissible discrimination. So if you do well in psychometric testing, you can't serve on a police force. Hence, you have, in actuarial speak, go read Jordan versus the city of New London if you haven't read it. Actuarial speak is that you have a police force that is systematically not in the top 1 or 2% on psychometric testing, and they end up going on television, and you look, they did something incredibly stupid. How could they do that? It's because there's nobody smart showing them how to do anything else. And well, why aren't smart people part of the police force? Because, at least according to Jordan versus the city of New London, you're not allowed. It's permissible to discriminate against people with high IQs. Now, I found that to be appalling, but I did talk to one of my high IQ people, and they go, well, they can discriminate with people with low IQs. I guess you could discriminate with people with high IQs too. The only problem is the result. The result is what you're seeing on television. Bad decisions, poor policing, and it could all be changed. Problem number one. Problem number two, the mental health issues, totally not addressed. It is obvious to anybody who reads DSM 3 and 4, 5, whoever wants to look at the Diagnostic and Statistical Manual of what they call people that are psychotic or high neurosis. Mental issues are causing a lot of the problems out there. But we don't have a place for mental health. Instead, we stick them all in bloody jail. They're all in this little bloody jail thing together because we have no mental health system that works. Our criminal justice system is completely broken. And if Biden wants to help out, don't look at, hey, we're going to reform the court. Look at reforming our criminal justice, or as some people say, our criminal injustice system from the bottom up.
Well, gentlemen, the reason why I asked that question is simply because of this. I mean, we were all focused in on expansion of the Supreme Court, which, may be one of the recommendations. And although Biden has expressed a disdain at this point for that particular option, when he broadened the language to a reform of the entire court system, that was an overture to the progressive wing of the Democratic Party, precisely to attack these types of issues. And then that's the kind of the reality that's there. And you see how complicated it is. So, I'm kind of curious about how far it goes. And it becomes one of these things. Once you open up the can of worms and you start to get into it, it can lead to all kinds of different areas. Now, would you guys be for limiting this scope of review in any way, shape, or form, maybe just to just federal issues, constitutional issues, criminal justice issues, civil procedure, matters of civil procedure? Or how would you go about structuring it if, in fact, we are looking at a presidential commission which is only going to be limited to 180 days to study and make recommendations? So, Adam, you want to go first?
Well, my problem, first of all, with his entire proposal is that the idea that you should be reforming the courts misses the point. What you need to be doing is getting the legislatures to do something, to attack the idea of qualified immunity, okay, to address what Nick said, the way mental health issues are treated in the criminal justice system. I know enough people who have decompensated while in prison in the criminal justice system, and when they're released, they have no support on reentry. The federal sentencing guidelines are way too strict. Sentences for some felonies are way too long, and discretion is way too limited. What I would do with the courts, though, is having, I was a litigator for 5 years, and it is so slow. I mean, you could sit there for 2 years in motion practice and then have another 3 years in discovery in a major class action. It's so inefficient. Mm-hmm. So I don't know exactly the specific solution, but my approach generally would be, let's make it more efficient in how cases are litigated.
Okay. I'm going to vote for Adam, and let's cut the red tape. Now, Jeff, what do you think of Adam's solutions? Because, I mean, quite frankly, I think America's crying out for reform. And while it may be wide, it may be large, isn't this the time when we have the momentum in our society to honestly take a look at dusting off and getting rid of some of these things that have been around, say, for 200 years that are no longer necessary, like originalist theories?
I think he threw something in there, Jeff. I wasn't sure.
Here in Utah, a few years ago, they tried to make cases more efficient by limiting discovery based on the size of the case. They went to a system of 3 different tiers of cases, depending on how much they were worth and so on. And you have to file a motion to get more discovery than your tier would normally allow if you need more, and you have to go in and justify it. I have mixed feelings about it because, number one, it complicated the system. There's 3 different sets of rules instead of 1 now. And then secondly, if you want more discovery, you get to file yet another motion. And I'm tired of motions. I mean, I've been filing motions for 25 years. I've had it with motions. I think in a way, every time lawyers try to fix the problem, they make it worse. And the reason that I believe that is because lawyers love rules. So every time there's a problem, they think, let's make another rule. And every time they make another rule, they make it more complicated. So I'm with Shakespeare. First, kill all the lawyers. Don't let the lawyers try to fix the problems in the legal system, because all they're going to do is screw it up worse.
Nick, I mean, I cannot stand in the way of a gentleman with the same spirit, because Nick does not read Shakespeare for precisely that reason, Jeff.
No, none of those books are Shakespeare's. I burn them every time I see them, because he makes condescending statements against the legal profession. And the problem is not the legal profession. The lawyers are, for the most part, they're trained in the law, they understand the law, etc. The problem is we have 330 million people that are not trained in the law, that don't know anything about it. We have some systems that are antiquated. One, I think, that's being pointed out is our criminal injustice system that exists. And we even have a show on IBM TV called Weed Wednesday. Yep. Now, what's this all about? It's about people in California, that's supposedly progressive, that got caught with marijuana 3 times and are now in prison for life. Now, in my calculus, that doesn't make any sense at all. Yet that's what's going on in the United States of America. And so what we do have is we have a criminal injustice system out there that needs reforming badly from the bottom up. Now, to expand or contract the court won't do it. It goes back to what Adam says. It's your state legislatures and the federal government that needs to get a handle on this criminal injustice system and make it a criminal justice system. And it's going to take some legwork to do it. And I also agree with Adam, concur with my esteemed counsel from Georgia, that we should look at how other countries work and their legal systems actually do work very efficiently, and how they keep crime actually down and how they treat crime. We're very insular. We go, well, we're going to create the solution ourselves without looking abroad. And I would like to bring on, and we're going to bring on, some subject matter experts around the world on IBM TV to see how they handle their legal systems, which are totally different than ours.
I have just one suggestion for reform. Remember, it's humble. It's from a JD, so there are no grand expectations. And it shouldn't be controversial because we ask for so little, just the mere crumbs, sir, just crumbs. Why don't we punish people who bring frivolous lawsuits by slapping them with fees?
No. Well, see, here's the problem, Bill. You go back to the subjective, what is considered frivolous, and
it works in Great Britain.
And well, I mean, but see, that's the real problem. In other words, what is considered frivolous, and that again is subjective decision. A lot of things like that can be quantified, and there's a whole group of people. I have to bring them on. One is Chicago Kent Law School, doing a lot of work in legal tech, and actually at Campbell Law School, which I did teach for one class before they said I I made them work too hard. I don't get that one yet. Okay, but the thing is, there's a professor there that also is into using technology, and we have another interesting thing that's going on practically in the legal system. You know, this whole thing, you have a right to trial by jury. Forget that one. Wait, that's in the Constitution. Maybe. Okay, most cases are not heard today by a jury. It's less than 7%, and maybe be going down, Bill, to 3% of the cases will actually be held by a jury. In a lot of the cases, you don't have a right to a jury trial. So this whole myth of a right to the jury makes the normal person feel good. Oh, well, I'll get a chance to go in front of a jury. But that's not true. A lot of cases, you're never going to see the inside of a jury. You know, you can forget it. And again, I am also not sure if the jury system, that's wrong, that there's a certain amount of things that probably shouldn't be held before a jury. But what we're seeing right now is the judges, after listening to the facts, are making decisions as a, quote, matter of law. And hence your case never gets in front of a jury, ever.
Okay. Well, that was quite a lot to unpack, Nick. Because on the one hand, you're blaming the grinding down or the unnecessarily high expectations that the American public has of the American judicial system on Hollywood. You're saying it's Hollywood's fault because
it's not Hollywood's fault. It's just the reality. This right to jury is a myth. Okay, a lot of cases will never see the inside of a jury. The judge will sit and look at the facts and say, I'm going to rule as a matter of law, and they will never present iota one to a jury, my friend.
You're certainly not suggesting that one of the say 17 points of reformation of our judicial system ought to be the abolishment of the trial by jury of your peers.
You mean it's trial by judge? Right now it's trial by judge. Forget jury. You can request a jury trial all you want, and good luck of ever seeing a jury.
Okay. Wow. Can somebody bring me a lamp of hope? Mr. Lamparelli, can you bring me a
lamp of hope? Lamparelli,
apparently,
a lamp of hope
believes in extinguishing all hope. About this jury system or anything else, please. And then, Jeff, I'm coming to you.
Well, I think one thing that isn't really discussed about much is the interplay between the courts and the legislature. When you look, for example, in 1990 at Employment Division versus Smith, cited by Justice Scalia, a religious liberty case, the Congress didn't agree with the decision. So what did? They passed a statute, the Religious Freedom Restoration Act. We have doctrines in constitutional law, the insanity defense, the strict standard for ineffective assistance of counsel, where from 1984 to 2000, there wasn't a single ineffective assistance of counsel case found, where the insanity defense is used in 1% of criminal cases and fails 75% of the time in those cases. What is the legislature doing to address the inequities that result from these doctrines? And again, I don't look to the courts to solve the problem. I look to the representatives.
Yeah.
All right. Well, going back to your original question, which I think was about awarding fees for frivolous lawsuits. Two points on that to begin with. Number one, we have Federal Rule 11, and I think in every state except maybe Louisiana, we have a Rule 11, which says that when any attorney signs a pleading, he is saying or she is saying that based on good faith investigation of the facts and law, this was not a frivolous case. So you can already award attorney fees against someone for bringing a frivolous action. Now, we also have in Utah fairly stringent loser pays rules. And I used to be a big proponent of it. Having lived with it for a while, I don't know that I feel that way anymore. And I'll tell you why. Because you get to a point in litigation where the attorney fees take over the case, where the fees on each side that each side has racked up are so big that you got to win at the end in order to pay your fees, or you've got to make it worth it. And the amount of money that is at stake in the fees can be bigger than what's at stake in the litigation. And so it actually is an incentive for people to go to all the way to trial instead of settling. And I don't like that. I think we ought to encourage parties to settle cases, get them out of the system, give both parties something they can live with, and have the private parties settling stuff instead of judges settling everything. So that's I guess one of my misgivings about that idea. In terms of what Adam said, I agree. A lot of this stuff ought to be decided by the legislature. I'm not suggesting that the legislative branch is the final word on what the Constitution says, but I think that's where people need to look at people they can vote out of office the next time if they don't do their bidding.
Yeah. And see, the thing is, it's real easy for us to sit on the lawyer's den and say, well, the legislature should do something. But have you ever seen the organization, the Cause of Concerned Criminals? In other words, the Organization of Concerned Criminals that go to the legislature in their lobby groups to try to get criminal reform? Or have you seen the Organization of Mental Health Problematic People go in front of the legislature to get things changed? No, you don't. See, the real problem is that this disenfranchised group has no voice and they have no money. Very important. Because if you have a voice with money, you'll be heard. If you have a money, you probably have a voice, you will be heard. But if you have no money, you have no voice. And so what happens, the legislature ain't going to do anything because that group of people don't have the voice and they don't have the money. It would be good in theory that they did something, but again, they have to organize and also address the problem. And I believe a lot of the problem is in the mental health system that doesn't exist in the United States, that needs to be reformed because a lot of people are sitting in jail. As a matter of fact, there was a study done, 1/3 of the people in jail right now today are not because they belong in jail, it's because they have mental health issues. 1/3. Yeah.
Hey, well, it seems to me, because two things are true. One, we always run the trains on time here, Nick, and I will be coming back to you shortly, but I'm going to take this moment of personal point of order, and that is simply this, that you see that when, a couple of days ago, when Biden said that the words of a president matter, his words today that said he's looking at 6 months to get suggestions to reform the entire court system, we can now see how daunting that is because it reaches into so many areas with so many divergent views and so much to correct. But I do know this, that at least the suggestions here, I got you. Okay, yeah, okay. The suggestions here point our way and lead light all the way back to Nick. Nick, you have the floor.
Oh, one more thing that happened while you guys were looking at LBGT rights or Roe versus Wade, the Purdue family just took $10 billion after their company filed bankruptcy when they flooded the United States with opioids, which killed over 70,000 people. And that's getting all pushed under the rug through the bankruptcy courts as we sit, getting very little love because we're spending time with Roe versus Wade for the 18th time, why they're embezzling, basically siphoning off $10 billion, the Purdue pharmaceutical company, to their family. And you got to look at that case, Bill. $10 billion out of Wilson, North Carolina, by the way.
Yes, $8 billion in the proposed settlement today, and that is significant. OxyContin, which is a scourge that continues to destroy many places in our country that can least afford it. But that's going to have to wait for another day.
Yeah, it will. But see, the thing is, cases like this need to get national attention as opposed to all this stuff. Not to say Roe and all the things that you guys love to talk about are important. They are, but they have their place, dude. These people are siphoning off $10 billion and killing 70,000 people, and we ignore it because it's white collar.
Well, gentlemen, we are at 7:59, and if there's nothing else I have learned from my mentor and cherished friend, Mr. Palavita, the mouth of the South. I've learned when to shut up, and at 7:59, it's time for me to shut up. So with that in mind, I will turn it over to my mentor with great acclaim. Nick,
yeah, and we'd like to thank our panelists today on the Lawyer's Den. We are more interesting than Judge Judy, unless you want to see somebody who didn't pay their rent sue their sister for the 400th time, And the thing is, I don't watch her anymore. I like her show. It's Small Claims Court. You can go see it live and in person, but they will not talk about things that matter, like Purdue Pharmacy siphoning off 10 billion, maybe it's 8 billion, but the family got 8 billion by just being illegal thugs, and we're all okay with that because we're going to go devote our time to these other cases. But with that, thank you everybody for watching The Lawyer's Den. We will see you on Monday, hopefully with our international experts coming in.